I'm going to be speaking to you today instead of Natalia. I know you've probably gotten very used to her talking with you on Thursdays, but she's taking a well-deserved vacation. Today I'm going to talk to you about some updates in the immigration situation. There's a couple things going on that have happened recently that we think it's important that viewers should know about. First is immigration reform. It's a topic that's on a lot of people's minds. It's been something that we've talked about for years happening, and still nothing has happened. But there has been a positive step forward recently. The House passed a $3.5 trillion budget outline. Now, it is an outline and still a lot of work needs to be done, but it set aside over $100 billion in that budget to address immigration reform, including passing a path to citizenship for dreamers, as well as a path to residence for those who've had TPS for long periods of time, and also farm workers. These are all people that the majority of Americans support getting some kind of legal status. So hopefully, as it progresses, we will finally see some kind of limited reform. Now, why is it important that it's in this budget bill? It's important because if the House passes the ultimate budget that includes the language and who would be included, then when the bill goes to the Senate for consideration, they only need 51 votes to pass it versus the 60 that currently is needed for most things that involve immigration reform. It's a hyper-technical thing, but it's called reconciliation, and it has to do with bills that allocate money. So if they've included this in this bill, the Senate could pass the budget, including these immigration reform measures, with only 51 votes. That means the entire Democratic caucus, which is 48 members plus 2 independents, would vote for it, and then Kamala Harris would be the tiebreaker as the vice president. So we could realistically see immigration reform sometime this year. It still has a long way to go, but it is at least a positive step forward. The next topic I want to discuss briefly is prosecutorial discretion. It's come up in the news recently because a U.S. District Court judge in Texas, let me be accurate, issued a preliminary injunction. What has happened is the states of Texas and Louisiana filed a lawsuit against the federal government regarding the enforcement priorities that were set up by ICE. And I think that those states could use resources in better ways. They have much bigger problems, in my personal opinion, including the current surges of COVID. But this is what their governors and attorneys generals have decided to do with resources. So they sued the federal government to stop them from enforcing immigration in a prioritized manner. Essentially, that means instead of focusing resources on serious criminals, national security threats, people with multiple immigration violations and fraud, Texas and Louisiana want the federal government to essentially go after anyone who's here undocumented. Now, in theory, I get some people say, well, they're undocumented. The reality is our Immigration and Customs Enforcement Department does not have enough resources to tackle every undocumented person. So the priorities were set in order to focus on the more serious and dangerous populations, and at the same time give a little stability to people who don't pose a threat to the security of people in the U.S. or our national security as a whole. So this injunction has been stayed temporarily, which is good. Litigation is still ongoing, so we'll see what happens. But one of the spillover effects was how it would impact prosecutorial discretion by the ICE attorneys in removal proceedings. And at first, when the preliminary injunction was put into place, the Biden administration notified their attorneys that they shouldn't follow the guidance regarding enforcement priorities, but they did not say, do not exercise prosecutorial discretion. They told the ICE attorneys to continue to exercise prosecutorial discretion on a case-by-case basis, but not to rely on the priorities that the judge had said they could not use. So this means prosecutorial discretion still is moving forward. And you may be wondering, what exactly is prosecutorial discretion? It covers a lot of different things, but basically it's the the ICE attorney's ability to decide, should we move forward with this case? Should this case be closed? Should we reopen this person's removal order because they have some kind of way to stay here? It's a lot of different factors. And this can really help a lot of people. It also helps relieve the overload in the immigration courts. Right now, it's estimated that there's 1.3 million cases in the immigration courts nationwide. I could tell you personally, I recently did what's called a master calendar hearing. It's a preliminary hearing regarding the status of a case. And at that hearing, you set your date for trial, meaning the actual hearing on the matter. I asked the judge for the first available date. Due to the overwhelming number of cases in the immigration court system and the shutdowns caused by COVID-19, the first available date for my case was 2024, 3 years from now. And this is not because we asked for a later date or have postponed. This was the very first hearing, and we asked for the next available hearing for the trial. So prosecutorial discretion can help judges get to the cases they need to get to. There are a lot of cases. There's meritorious asylum claims that are stuck behind cases that are simple green card cases that could be sent back to USCIS and handled there. These are just clogging up the system. So this prosecutorial discretion can help. It doesn't mean everybody gets a free pass. Even if they agree to dismiss some cases or close some cases, they can reopen these cases and revisit them. So it doesn't mean it's amnesty, because I hear that term thrown around a lot, that it's a secret amnesty. It's not. It's just a tool to focus limited resources on the most important cases, and at the same time not using those limited resources in situations where you have a long-term resident in the U.S. who has extensive family, who is working, taking care of their children or other family members, and the sole reason they're in removal proceedings is because they're here without status. We could focus those resources much better on, again, criminal aliens, national security threats, and people who've committed fraud and multiple immigration violations. Next up, COVID-19. We've all been living with it for the last 18 plus months. We're all probably very sick of it and would like to get things back to normal. I know I would. In an effort to help get the numbers down and prevent the spread, the CDC announced recently that as of October 1st, 2021, anyone having a medical examination on or after that date in connection with a green card application will now be required to submit proof of vaccination for COVID-19. There will be some limited exceptions. Those obviously apply to children under 12, or as the age changes, as more research is done, anybody who cannot get the vaccination because of age will be excluded. Anybody who is, where the vaccination is contraindicated, will not have to get the vaccination. For example, if you had the first shot of either Moderna or Pfizer and you had a very negative reaction, you will not be required to get the second shot. Or if you have some other medical condition that the doctors do not recommend you getting the vaccination. The other exception will be if the vaccine is not readily available in your area. Now in the US, I think there's very few places that would actually apply, but of course as time changes there could be shortages. So if there is a shortage in the vaccine, you will be given a blanket exemption. And as always, the religious and moral exemptions will apply, which you have to specifically request. They will not be blanket. So you will have to submit an actual reason why it would be against your religious beliefs or moral convictions to get the vaccination. Please note, this is a very high standard to meet. You have to prove that these are deeply held beliefs. They're not going to just exempt you because you say, I'm Catholic and they won't let me have it, or I'm Jewish and it's against my faith. You're going to actually have to show how it does intertwine with your faith. And the last thing I'd like to briefly mention today is changes to the asylum application process. Given the quote-unquote crisis at the border, I say quote-unquote because this has been going on for years. It's often cyclical, that we have people show up at the border. Yes, there have been more people more frequently, but this is nothing new. A lot of people are coming to apply for asylum, and as it stands right now, these individuals are given what's called a credible fear interview with an asylum officer. And if the asylum officer finds that they have a credible fear of persecution or torture, they refer their case to the immigration court. Now, this is adding to the 1.3 million backlog. Typically, if you're in the US and you're not at the border, but you're here and you apply for asylum, you go to your asylum application is reviewed by an asylum officer, and that asylum officer can decide to grant your application, which means you're granted asylum, or they can refer your case to the immigration court. What happens with the people at the border, like I said, they have a credible fear interview. That is not the same as being granted asylum. So these people, in order to get asylum, have to still go to court and convince an immigration judge that they should be granted asylum. Now, if the proposed changes would allow asylum officers to grant asylum, so there would no longer be a credible fear interview, essentially. The asylum officer would conduct a traditional asylum interview, and if they find the applicant is eligible, they would grant asylum as if the person had filed in the US. This is good because a lot of meritorious cases could be granted and no longer go into the court system. This means people are granted sooner, they're not subject to detention, they can be out legally working and living in the US and establishing lives here. If they're not granted, they would have the right to appeal the decision in the immigration court system. So that means there's still going to be cases that end up in the immigration court system, but a lot of them may not. So it's positive. The other positive out of this is asylum officers are specifically trained to deal with people who have faced trauma. This is important because a lot of people who come fleeing who have been persecuted or tortured have difficulty explaining what happened to them or opening up, because a lot of times the abuse happens at the hands of government officials, and even though they've heard the US is safe and good, they're still scared. So these officers have special training to help get people to open up to them, give them information. They know how to ask questions in different ways to get the information they need to make a decision. The immigration judges and the Department of Homeland Security attorneys don't have the same training. And so a person who's already been traumatized and is scared, and now they're sitting in a courtroom with a judge and a government attorney, may be scared, and it would be natural for them to be scared, and they may have a hard time explaining themselves. And this could lead to denials of cases where there may actually be good grounds to grant asylum. The regulations are just being proposed. They're going to have to go through a rulemaking period, so we don't know what the final outlook will be, but I do believe this is a positive step forward. It will help relieve some of the immigration court backlogs. It will also help people who have meritorious claims get granted sooner. And it will also discourage people coming and abusing the system. And that includes smugglers who prey on people. Because right now, you get here, you pass a credible fear interview, and then you're put in the immigration court system. And like I told you before, I just asked for a first hearing 3 years from now, where people get to stay in the country, and smugglers and other people use this as a selling point for their services. So we can start getting rid of some of these things. So again, there's positives. Thank you for taking the time to listen to me. I hope it was informative. If you have any questions, please feel free to post some comments and I'll answer them. Or if you have specific questions about your own immigration matter, please give us a call at 212-840-0050. I thank you again for listening and have a great day.